Good afternoon, this is Sean Golding with Golding & Golding here to update our prior presentation on Streamlined Domestic Offshore Procedures, otherwise known as SDOP. Let's just dive into it. So the Streamlined Domestic Offshore Procedures are one of the two different programs available under the Streamlined Foreign Filing Compliance Procedures. So you've got the Streamlined Filing Compliance Procedures, that's the main title, and then you have two versions of the program, the Streamlined Domestic Offshore Procedures, Streamlined Foreign Offshore Procedures. The focus of this presentation is the domestic version. It's still for offshore accounts. It's just domestic because the taxpayer does not qualify as a foreign resident. The program is more popular, let's say, than Streamlined Foreign. While everyone wants to qualify for Streamlined Foreign because there's a penalty waiver, it's difficult to meet the foreign residence test for most people. So, under Streamlined Domestic, you have to be a U.S. person. You do not qualify as a foreign resident, and you are non-willful. Now, U.S. person for tax purposes means you're filing Form 1040, not Form 1040-NR. You don't qualify as a foreign resident, which means you didn't live outside of the United States for at least 330 days in any one of the past 3 years, or if you're just a visa holder, you didn't meet the substantial presence test. Non-willful is the key issue under any version of the program. There's no bright line test. It's basically a totality of the circumstance. You look at the facts. It's a smell test, right? If you intentionally avoided reporting, you're going to be willful. There's subcategories to willfulness such as reckless disregard and willful blindness, but those aren't really common. More often than not, the taxpayer is going to be non-willful. They just didn't know. The CPA didn't ask the right questions. The taxpayer misunderstood the organizer, and so here they are, and they want to get into compliance. Some of the benefits to the Streamlined Domestic Offshore Procedures. One, there's a limited penalty. You read online all these horrific penalties, $10,000 per year for the FBAR that adjusts for inflation. So now it's like $15,000, $10,000 a year for the 8938, the 5471 penalties, 8865. Under the streamlined procedures, it's a 5% Title 26 miscellaneous offshore penalty. So in lieu of all that other stuff you've read, you get hit with a 5% penalty. And not all items are penalized. Most of them are. But for example, Canadian retirement such as RRSP, RRIF, and other pension plans, they say, can escape the 5% penalty. And real estate investments can typically avoid penalty as well. So what that means for the real estate is that if you own individual rental properties, let's say, you don't have to pay the 5% penalty on the rental property. If that rental property is unfortunately in a certain type of entity and that entity can't be disregarded, then the value of that entity will be totaled up as well for reporting purposes for the penalty for Title 26. So individually owned real estate you could typically avoid. If it's in an entity, that value is included to determine the value of the entity to determine that 5% penalty on that asset. Under these programs, you can use the foreign earned income exclusion and foreign tax credit. So oftentimes, a taxpayer may not have any tax liability and a much smaller penalty than they would have had if they were audited and penalized, or if they were just penalized before an audit, like they filed it late and then they got dinged. A few other requirements to keep in mind about the Streamlined Domestic Offshore Procedures is that you can't be under audit or examination. If you are, you're supposed to provide the officer or the agent with that information, as uncomfortable as it is. Your audit or examination may have nothing to do with your offshore reporting, but still, from a technical standpoint, you're supposed to report it during the audit. So this goes back to the concept that it's a timing, right? You want to get the information submitted, the package submitted as soon as you can, relative to getting it done as accurate as you can as well, and having the information necessary to present it to the IRS. If you've already been penalized on these assets, you can't avoid the penalty or reduce your penalty by doing streamlined. Again, it's a timing issue. With Streamlined Domestic Offshore Procedures, you had to file original returns, and technically the IRS uses the word timely. So you're not supposed to file original returns with the Streamlined Domestic. It's supposed to have been filed timely, including extensions if it's a few days late. We've spoken with agents before and they make it seem like there's a bit of a gray area, but you miss any more than a few days or a week or so and they're not going to accept your Streamlined Domestic. We have a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter, and it's something that we handle here Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.